Thank you very much. Dr. Rodriguez spoke very eloquently about a lot of our concerns in relationship to a constitutional convention, and I just want to expound on them a little bit. Constitutional convention is a general assembly on steroids, exempt from none of the political influences that plague the legislature, tasked only with evaluating and redefining our basic constitutional rights, and in the end, accountable to no one. It's not speculation, but it's a certainty that a constitutional convention will leave civil rights and civil liberties open to debate and ultimately dissolution. Despite the best intentions of many of those who call for a constitutional convention, and the ACLU certainly shares many of their frustrations with the General Assembly, our own experiences in Rhode Island and the experiences of ballot initiatives nationwide demonstrate very starkly the dangers of a constitutional convention, and those dangers should not be ignored or minimized. Despite the purported focus of the 1986 Constitutional Convention being that of good government, some of the most significant measures to come from that convention focused on abortion rights, restricting the voting rights of felons, restricting the right to bail, and more. And time has shown that what happened in 1986 is not an aberration. Once a convention meets, there are no limits on the issues that it can address, and conventions can serve as catalysts for socially divisive amendments that threaten our most basic civil rights. Looking at ballot initiatives across the country, we can get an example of what it is that we can expect to see. And since 1986, there have been at least 18 anti-abortion initiatives put up for voter consideration, 4 initiatives to ban affirmative action, 5 initiatives to require English as the official language, 5 initiatives to ban equal rights for gays and lesbians, 9 various anti-immigrant measures, 13 initiatives to ban same-sex marriage, and most recently 11 initiatives aimed at restricting state participation in Obamacare or restricting the ability to create a state health exchange. That is what we can expect to see in Rhode Island and more. Constitutions are supposed to protect certain fundamental rights from the will of the majority, but a constitutional convention allows a simple majority to take away those rights. That the courts can eventually nullify some provisions of the Rhode Island Constitution that we enact that may conflict with the U.S. Constitution is no protection anymore for those individuals whose rights will be suspended or obliterated by a constitutional convention. Courts move very slowly. They take years to come to a conclusion on these matters, and that a court may one day overturn a decision made by the voters is going to provide very little relief to the individuals whose rights are restricted or denied in the meantime. That's what we've seen with same-sex marriage, couples whose rights have been suspended in the years that it has taken courts to come to these decisions, and of course the women who are living in states enforcing unconstitutional restrictions on reproductive freedom, or whose courts have chipped away at the Constitution. Since 1986, the courts have become much less protective of the rights that are so often the subject of ballot initiatives and constitutional conventions, including abortion and, as we saw with the U.S. Supreme Court just last week, affirmative action. Courts can no longer be counted on to declare unconstitutional the things they should. Constitutional amendments deserve very serious consideration, including robust debate and careful drafting, a process that cannot occur in a constitutional convention. Our Constitution is not a document that should be so subject to wholesale revision, and the ACLU opposes a constitutional convention. Thank you.